Hello, this is Attorney Brian Pendergraft of the Pendergraft Firm LLC, and I just thought I would shoot a quick video to coincide with my latest blog post on the eviction prohibition for tenants that are suffering a substantial loss of income as a result of COVID-19 per the governor's orders, actually. So, and here I have the Governor Hogan's order actually pulled up in front of you. That's what this is right here. And this is the actual order that I based that blog post off of on. So here, as you can see, the name of the order right here, what it does is it's order of the governor of the state of Maryland, temporarily prohibiting evictions of tenants suffering substantial loss of income due to COVID-19. So the intent of this order is to protect tenants or give tenants a new defense that are suffering a substantial loss of income due to COVID-19, as long as Maryland is in this state of emergency where people are essentially losing jobs, losing work, and unable to pay their rent. So that said, there are conditions to this rule or to this defense, and I'm going to scroll down to the relevant portion on page 2 and kind of interpret that for you. Now, again, I think I get more detail on the blog post, but this is going to be a quick overview. So right here, starting at number 1, until the state of emergency is terminated and the catastrophic event health emergency is rescinded. So what that's referring to, of course, is this COVID-19 crisis that we're going through right now. The effect of Section 8-401 of the Real Property Article of the Maryland Code. Now, that is failure to pay rent. That is the statute that gives landlords the authority to file for failure to pay rent. That is Section 8-401. I have a video on that, too, if you would like to see it. I'll put the link to that in the description. So, and it says that it is hereby suspended as follows. So what it's going to do now is by that it means that the next paragraph, essentially the following paragraph, is going to limit a landlord's remedies when filing a failure to pay rent action. So we're going to go down here to A. It says no court shall give any judgment for possession or repossession or warrant for restitution of possession or repossession of residential real property. So essentially, a court shall not, translation, what that means is that a court will not order an eviction, essentially, or they will not order they can't order the sheriffs to, or give sheriffs the authority to carry out an eviction. That's probably the best way of putting that. So no evictions are going to be evictions won't be taking place for residential real property. So the key here is that the key here is residential, not commercial. So if you're a commercial tenant, then this protection does not apply to you. This only applies to residential tenants. So if the tenant can demonstrate to the court through documentation or other objectively verifiable means that the tenant suffered a substantial loss of income resulting from COVID-19. So what that is saying is that the burden of proof is on the tenant to objectively show that they have suffered a loss of income due to COVID-19. So they can't just walk in there and say, hey, perhaps I've lost my job, or, COVID-19 is the reason why I'm hurting. They can't just walk in there and say it. They kind of got to bring proof that shows or proves the case. The burden of proof is on the tenants to show that. So let's see, or the related proclamation, state of emergency and catastrophic health emergency, including without limitation to, due to job loss, reduction in compensated hours of work, closure of place of employment, or the need to miss work to care for a homebound school-age child. So essentially what that's doing is that is giving you, that's essentially giving the court guidelines or the types of examples where a tenant would, qualify, for this defense. So if you are a tenant and you are missing work because you have to take care of a school-age child now, or perhaps you've lost your job. Maybe you can't go to work. Maybe you're a server at a restaurant, so you can't go to work anymore. Those are example conditions in which you are protected by this order, and your landlord cannot get a warrant of restitution against you and evict you, essentially. So this is good for both, landlords and Maryland tenants to know. So I hope you guys have found this helpful, and I get a bit more in depth in the blog post. So be sure to check that out. All right, take care.